Hi, I'm Sabrina Winters, and I'm an estate planning and probate attorney in Charlotte, North Carolina. While we're waiting for some of our attendees to join, I wanted to just make sure that I said thank you for being here today. Congratulations on knowing that even if this is really a difficult topic for you to address, that you're still here and you're still getting it done and you're still wanting to learn about it. I'm originally from New York, but I have practiced in estate planning for almost 20 years. And I've had my own practice since 2005. And in the webinar, you're going to learn more about what my purpose is, why I chose estate planning as my career, and why I think it's so important for you to really understand the dangers of not having an estate plan in place, especially during a separation or post a divorce. I am not divorced and I have never been divorced. But when I tell you that I have been through the estate planning process with nothing in writing and that I have really connected with my clients who are divorced and separated and are women, unfortunately, the theme across almost all of them is that they didn't have anybody supporting them. They didn't have anybody empowering them to take those next steps in their lives, helping them educate themselves. They didn't have what I had during a lot of the struggles that I've had really to get to this point in my life. So I want to make sure that you're getting what you need to get out of this presentation. And I'm going to do my best to explain my why for myself, the why for you to move forward, and the why is it so important to get this off your plates now. So I want to thank you again, and let's get this presentation started. Hello, I'm Sabrina Winters, and I want to make sure that everybody is on the right webinar and you are here on purpose. Today, we're going to be talking about the 4 estate planning dangers that separated and divorced women must address today. Before we start, I do want to talk about a few things. I know that your time is super important, so I don't want to take up too much of that today, but we'll be together probably about 30 to 45 minutes. I want to make sure that I'm covering really the important things that you need to think about. And then when we do have our meeting, we're going to talk way more in depth. But these are really the things that I want you to start thinking about. What we are going to talk about is really focused on North Carolina statutes. Although most of it is going to apply from state to state, every state has their specific way that they want you to handle these things. So you will always need to find an attorney in your state that handles estate planning so that you can discuss these matters with them and how it is applicable to your situation in your particular state. And of course, as a disclaimer, anything that we're sharing today is not legal advice. It's really a way to make you aware of some of the dangers and what of the things that you need to think about so that you can seek the right guidance from the right attorney for your particular situation. Our agenda today is going to be very simple. First, I'd like to talk to you about why do I care and why do I do what I do? And that comes from my personal story. I want to give you a very general overview of what estate planning is, because although everybody needs an estate plan, this is particularly geared towards women who are separated, going through a separation, or are currently divorced. I'm also going to talk about how you can be empowered by what you learned today, because it is really important that what you get from our time together here is empowering you to take your life in the direction now that you want it to go in. And I want to be a little bit of that push for you to get this started. And then we're going to focus on 4 estate planning dangers that every separated and divorced woman must address today. What's Sabrina's why? Well, it does go back about 20 years ago. My uncle was very sick at the time that I graduated law school. And by the time any of us really knew what he should have done, it was too late because he had lost his ability to make these decisions for himself because he did have dementia at the time that he passed away. What happened to our family was awful. When he was in the hospital, we all still feel this, that he knew exactly what was going on, but unable to communicate it to us. And because his spouse was flying in from another country and the family that was present in the States could not agree on what medical decisions to make for him, the only thing the physicians could do was try to keep him alive until my aunt arrived to the States. That was hard. It's very difficult to watch somebody be resuscitated. Our bodies don't recover the way the movies seem to share that we do. Your body goes through a lot after you've been resuscitated, and my uncle was resuscitated a few times. But the hard part, in addition to that, to get past was that his eyes were open the majority of the time. So we all felt like if he could just speak, if he could just have that option to say what he wanted, we didn't think he would want what was going on. So I had to watch my father watch his brother go through so much physical pain and agony and emotional stress without him being able to do anything. And that was difficult. It really was. And then I had to settle his estate without anything in writing. And so we were at the mercy of what New York law, because I was living back then, told us we had to do. We weren't guided. Nobody had the bedside manner that you would expect. Nobody had that compassion and understanding for his family to kind of tell us, we understand what you're going through. Let us help you. Let us take you by the hand and we'll do this for you. Nobody did. We did it all on our own. It was awful. It was long. It was devastating. And 20 years later, my father still questions himself on, did I do everything that I should have done and could have done for my brother? So that's why I do what I do, because I swore that day that my practice that I created was going to give clients the environment and the opportunity to avoid the things that my family went through. And I was going to be purposeful and authentic with every one of my clients. And I was going to share my story with every one of my clients. Because although then it was really difficult to go through, it's definitely not something that I wanted to keep quiet or keep to myself or act ashamed about it. It was something that I needed to bring into my practice and be purposeful in how I helped my clients. Why is empowering women so important to me? Other than the fact that I am a woman, I am proud to be a woman. I have really not been handed anything. Pretty much everything I have worked for has been a struggle. I probably have failed more times than I have succeeded. But when I look back at how I got through those difficult times, the majority of the time, there was a woman behind me telling me, you got this, you can do it. I've seen your strength. Don't give up. It was my mother. It was my sister. It was my best friend. I had women that got me through the hard times. I had women who were supporting me and guiding me and helping me and telling me to get up and just go do it and stop feeling sorry for yourself. And I see through my own practice that a lot of the currently separated or divorced women that I meet with sadly don't share the same story that I have. They've not had that woman in their corner encouraging them and educating them and promoting them and lifting them up. And I bring that into my practice because I truly appreciate and do not take for granted the powerful women that I've had in my life to get me to this point that I am proud to say we're part of my successes. And I want to be that part for you as well. So let's get into it. I want to start first with an overview of what estate planning is. And I know from from what clients call in and ask about or what we talk about at our meeting, estate planning is oftentimes a very misunderstood thing that people have to do. It's kind of this very obscure, I don't really know what it is. Do I even need one? I don't have money. I just started a new job. I'm not married. I don't have kids. I'm healthy. Like all of these things are questions and legitimate questions on really what it is and what you need to do when you are doing estate planning. So essentially, estate planning has to do with getting your wishes in writing so that your family and your loved ones know what to do during a time that you can't do it yourself. It's incredibly powerful for you to get these things in writing now because you get to have control when you don't have the ability to have control. I mean, how amazing is that? So you'll need to have a healthcare power of attorney, a living will, a financial power of attorney, a will, a last will and testament, and or a trust. Those are the basic, very, very basic documents that are part of estate planning. There are a lot more moving parts that essentially are under the umbrella of estate planning, but I don't want to focus on that today. The focus today is on you and what you need to do to get these in place. Leave the hard part to your attorney. Leave it to me to create these documents and get the information from you into these documents correctly. You need to take those next steps, learn how to empower yourself and why getting these documents is so important for you during the time that you're going through right now. So why are you here today? You or someone you know is considering a separation or is in the process of a formal separation or is separated, is currently divorced without children, or is currently divorced with children, regardless of whether they are minors or adults. Now, it could be you, or it could be a friend, it could be a family member, it could be anybody. All divorced women or separated or thinking about separation really need to consider estate planning and when you should take those next steps. Why dealing with estate planning during a separation is an absolute must. So if you're separated, the separation agreement should really include details of the separation, the property divisions, spousal support, and if there are any children, child custody and support. But what happens often is that your family attorney doesn't explain to you, and I don't think it's on purpose. I don't think it's for any other reason other than, they're really focused on getting you through whatever it is that you're going through at that moment, which I know is stressful and difficult and painful, all those terrible negative emotions that go along with it. So they're not thinking about the things that I'm thinking about for you, which is oftentimes why family attorneys and estate planning attorneys work together so often, is because we're each handling that part that we do best for you so we can focus on that one part for you. So I don't think it's on purpose. I just think it's because they're there to help you. And it's oftentimes not an explained part of it. But here's what's super important when you are getting a separation in place. When you're getting your written separation in place, there's oftentimes, or in my opinion, all the time, should be a clause in there that says you give up the right to each other's estates during the time that you're separated. That is really big. That is really, really big. What does that mean? It means that even during the time that you are separated, you are not obligated to give each other any parts of your estate. Now, this is different than the property distribution that's happening during your separation. I am talking about the fact that you pass away without a will. Can your ex now have the right to a portion of your estate that North Carolina, or the state that you live in, the statute allows them to have? Having that one clause in there is so powerful for you to empower yourself and move on and take your next steps. So what I like is making sure that the family law attorney is including that in the document, so that when you come to me to do your estate plan, we don't have to worry about your ex coming back against your estate, because you waived it in writing, which is one of the few ways that you can waive your spouse or yourself from being able to have that power and opportunity when the other passes away. Why dealing with estate planning after divorce is final is an absolute must. So if you're divorced, you're putting your life and your assets at risk by not creating an estate plan. Not creating a will or a trust to get rid of your assets when you pass away after your divorce is very dangerous. And not updating or getting new healthcare documents is dangerous as well. And I want to explain to you why. North Carolina doesn't have a backup if your ex is named as the agent to make medical decisions for you. So if you had a healthcare power of attorney and a living will while you were married, and you did not do new ones after your separation or your divorce, and something happens to you, it is likely that your ex-spouse is still the person that is legally entitled to make that decision for you. I am assuming, and I'm going out on a limb, that when you get a divorce, there are a list of reasons why you are divorced. If that is the case, with not wanting your ex to be making medical decisions for you, because not across the board. I mean, there are some divorces where exes are friends and you trust yourself to certain degrees. And maybe you do trust your ex to still continue making those medical decisions for you. And that is fine. I am not here to change your mind on that. I am just here to give you the scary part of not knowing that if you don't want them, that there is an option to do that. Changing the healthcare power of attorney is priority if you don't want your ex to be making medical decisions for you. The extra layer there is that they won't be able to end your life either. So if you also had a living will, the agent in your healthcare power of attorney is the one that's going to be making those decisions. So you should update both of them if you do not want your ex to be making those kinds of medical decisions. If you had a will or a trust, I would definitely suggest that you create a new one. Even though after a divorce, your spouse has assumed to have predeceased you when it comes to a will and having named him in there still, it just doesn't make sense to keep his name in there. It just makes sense for you now to get in your own documents those people that you want in there now, period. Not people that you shared as a married couple. Maybe you had your ex's family on your documents, because I see that a lot too. These new documents, post-separation, post-divorce, should reflect who you are now, what your wishes are now, what your goals are, and what your fears are now. And they could be completely different than what they were when you were married. And you need to make sure that you're addressing that as well. For immediate empowering things every separated and divorced woman must do now. Get your team in place, remove your former spouse from your powers of attorney, remove your former spouse from your will and or trust, and know your assets. Who is on team you? Who is it? You have to have a financial advisor. You need your own CPA and accountant. You need your own estate planning attorney. And you know what? You also need your own friends. That is really big. You shared friends. Maybe you're sharing the same friends post-separation or divorced. But you need your own friends who are going to make up your team. I had that support team. Not when I was divorced, because I was never divorced, but when I was single and alone, I had my mother, my sister, my best friend, and a whole team of friends who I knew were there. So think about your friends that are in your circle now, and are you keeping them in there? Are they on different levels now? Those are the things that you need to remember. A financial advisor is so important as well. You have all new assets, whether you split them, you took them, whether there's an additional life insurance policy. Like, there is a lot of financial things that are going on in your life now that may not have happened or were not going on while you were married. And you need to make sure that you are on track with that. And a financial advisor should be working very closely with your estate planning team so that whatever you are planning with your assets coincide with what your estate plan is supposed to be doing for you. So we're all playing a little part of your team, but your financial advisor really, really needs to be part of that. And now that you are separated or divorced, there's going to be some tax filing things that you need to know. So you need your own CPA or accountant at some point. I know that immediately post a separation as well as post a divorce, there may be a requirement that you file jointly. I'm not commenting on that. That's something that you need to speak to your CPA or accountant about. But I don't want you to forget to make that inquiry and have that conversation so that if it does apply to you, that you can now start filing separately, that maybe you're changing accountants, or maybe you are keeping the same one that you had while you're married. Those are your decisions to make because only you know what's best for you. I'm here to just make sure that you're having those questions on your list when you are talking to your CPA or your accountant. Number 2, take your ex off your healthcare documents. We touched on that a little bit already. I don't want to over talk it, but it is something that's very important. Do you really want your ex or soon to be ex to be able to make a medical decision for you, or worse, an end of life decision? Do you really want your ex or soon to be ex to be able to access your assets? If you were named on each other's financial power of attorney during a time that you were married, I want you to get a new financial power of attorney. Now these assets are in your name alone. If something happens to you and you are still alive, you need somebody that can help you with those assets. Ask yourself, do you want your ex to be that person? Or are you trying to keep the rest of your life, your financial life in particular, private from your ex? Do you want him to know all of those amazing assets you're going to grow your estate with after you leave each other? If you leave him on there as financial agent, he'll know possibly all of your assets in the future if you need to call upon him to help you with that. So think about it. Again, you all might be really good friends and have a fantastic relationship. It might even be something that is required in your separation agreement. Absolutely, you have to do what your separation agreement tells you to do, but you also have to know your relationship. Nobody's going to know it better than you. So always keep that in mind in all of the things that I am giving you caveats about. Remove your ex from your will or your trust. If your ex is an executor, if he is a beneficiary, and maybe as a trustee of a child's trust, all of these things need to be considered. Of course, none of them are going to apply if there is an agreement otherwise. So always reference your separation agreement, your divorce decree. Always talk to your family lawyer before doing anything drastic. But these are the things that you want to definitely think about before we need to call on this person to be able to do these things for you. And again, you're having your own life now. You're making your own decisions. You are creating a plan for whatever your needs are moving forward, which is why I want you to think about those things. Know your assets, part 1. This is really, really important. And across the board, I meet with clients who don't know what they own. They might have had it years ago. They put it away. They forgot about it. They've never needed to look at it again. They know it exists. They don't know how much it is. They don't know how it was owned. Nothing. I want to start with giving you a list of what is considered an asset. It's real property. That means your home, a vacation home, vacant lots, farms, checking accounts, savings accounts, money markets, certificates of deposits, the CDs, any vehicles or farm equipment, investment accounts, non-IRA, 401k or 403b, strictly stock and bond accounts. What about an IRA or Roth IRA, 401k, 403b? Don't forget, you also have assets if you're working, possibly benefits with your employer. You can't forget to keep that as part of the list of assets that you own. There's annuities. Maybe you own a business. Regardless of what percentage you have in ownership in it, if you own all of it or part of it, your business ownership is an asset. And of course, one of my favorites, pets. Now, pets could have been dealt with in your separation or divorce, but if you have a pet, that really needs to be considered an asset, because in North Carolina, it's property. They're not like our kids under the statutes. We treat them like our kids, but they're property. So you need to remember to address that if it's something that's important to you when you're getting a new will or trust in place. Part 2 of knowing your assets is, how is your asset owned? It can be owned by you alone. It can be owned by somebody else and you. If it is owned by somebody else and you, is it joint with rights of survivorship, or is it tenants in common? Do you even know how to look at a statement and know how it's owned? Is it an asset that has a beneficiary named? Is it an asset that doesn't have a beneficiary named? All of these things are super important for you to know post a separation and post a divorce. I don't care that you don't ever get an estate plan in place or ever speak to another attorney about this again. If you are looking to empower yourself post separation or divorce, you need to know what your assets are, and you need to know how they are owned. Because if you don't know those two things, you are likely thinking something will happen when you pass away that likely won't, because you don't understand your assets right now. So it's super important on how to address your life right now and make sure that you know your assets and how they are owned. I also want to make a point here in that there is something else also called TOD or POD. TOD means transfer on death. POD stands for payable on death. There are several assets that call a beneficiary a transfer on death person or a paid on death person. It essentially has the same effect. That asset passes to the person that is named on your passing. It's almost, and I say almost every time, an automatic. You typically need to only show a death certificate. I do want to caution those of you that are watching this that have children who are either minors or possibly under the age of 25, that first I want to address the minors. If you have children that are under the age of 18, you should not be naming them directly as a beneficiary, a transfer on death, or a paid on death, because North Carolina will not allow them to inherit directly. There's a whole other court process that you really do want to avoid your family and your kids having go through. But I also want to increase that caveat to 25 or maybe even 30, just as examples. I have plenty of clients who feel, even though my child is 21, there's so many life events happening right now that I don't want them to come into all of this money without any guidance, without anybody watching over their money and providing investment opportunities and ideas and options. If that's how you feel, you definitely need to address that in your will or your trust, because you can set up trusts for your kids after you pass away if they have not reached the age that you dictate. And I emphasize this point here because that plays such a big part in what we talked about earlier and why you need to know how your assets are owned. Because once your estate plan is done, you have to address the ownership and the beneficiary designations, because they typically need to mirror what your trust or your will says. So that's why this part is so important. And I want you to make sure that you are addressing these and making a list of everything that you have. Those, to me, are the 4 dangers that every separated and divorced woman needs to know and understand and address. But to me, they are also the 4 things that are going to empower you in the next phase of your life. You're taking your control back. You're taking your decisions on your own plate now. You're taking next steps on your own, but you don't really need to be on your own. You had your family lawyer helping you. You need your estate planning attorney helping you. You need your CPA on your team. You need your friends on your team. You need to surround yourself with the people that are going to have your best interests at heart. They understand where you want to be. They understand how you want to get there. And even more importantly, they're going to be there to get you there and help you get to where you're going. They're invested in you and you're invested in them. So what are your next steps? I definitely want you to go find your current documents if you had them while you were married. I want you to know where they are, and I would prefer that they are in your own hands. Some attorneys keep originals. I do not. If that's the case, contact your attorney. Let them know that you're separated or divorced. They'll have their own procedures on how they get you your original documents back. But I want you to find your documents, and I want you to hold on to them. Second, I want you to find your separation agreement and or divorce decree. I want you to always have those on hand, because when you're finished with your estate plan, those are important documents that need to be included wherever your estate planning documents are being held in a safe place. They should be together. Then I want you to inventory your assets. Know what you have, understand how they're owned, confirm if there are or are not any beneficiary designations. This is getting a lot of your to-do list ready that I'm going to make you do anyway when you come see me. So you might as well start now, because it's going to be a theme throughout working with me. And it should be the same theme working with any other estate planning attorney who understands the importance of why you need it right now. And I want you to schedule your appointment now to get your ducks in a row. There is no reason that you need to wait to talk to me. Once we talk, there might be a legal reason why you have to wait a minute. But if you've got a separation agreement in place or you are divorced, there typically isn't any reason why you can't start getting this estate plan in place, because you are taking those next steps to get to where you need to go. How do you schedule your appointment with me? The easiest way, because I know you're all busy, you all have a really busy, hectic, crazy life, visit my website. It's ncastateplanninginfo.com. There will be a button there for you to schedule a meeting with me. My meetings are in person. I think relationship is a big deal in estate planning because we are not transactional. Transactional attorneys are the real estate attorneys, the ones that are going to fight a traffic ticket for you in court. Those are one and dones. We're here for a specific purpose that has a beginning and an end that's very short-lived. With estate planning, we are not transactional. We are relationship based. We're going to get to know each other really well. So I do prefer an in-person meeting, or you can call our office and my assistant will schedule that for you herself. She does not mind at all. And that meeting typically is going to last about 30 minutes. And the reason I give a time frame, again, it's because you're busy, you have a crazy life, it's hectic, and you know you need to get this done like everything else. And I don't want to be the member on your team that you dread having to come sit with. And I promise you won't feel like that when we're done with our meeting. But I know that that is often something that is felt coming to see somebody like me. And my purpose is not to be that thorn in your side. My processes are quite different from many other attorneys. And I say that because I go back to the beginning of this presentation when I talked about I was going to set up my practice to be purposeful and intentional. So the way I've created my process is to make sure that this is as less stress on your plate as possible. The more difficult part of this, likely for you, may be just making the appointment. It might have been something that's been on your mind to do for a really long time, or it might have just been something that you decided you needed to do now because you saw an ad for this webinar, or this popped up somewhere and you said, I got to join. Whatever that reason is, I want to make sure that when we're talking, when I'm asking you to help me find information, it's always for a purpose. So we'll have our first meeting. It lasts about 30 minutes. I'm going to find out from you, what are you scared about? What are your goals? What do you want this to look like for your family when you pass away? Those are the things that are important to me to find out from you, because you're dictating what this plan looks like. I'm only helping you along the way, but you're actually making this plan every single time we have our conversation. At that meeting, we'll sign the engagement agreement, we talk about the legal fee, and then I send you an email that has some forms to fill out. Very, very simple. I'm just going to find out a little bit of address, name of kids, that kind of stuff, and a little bit more about your assets. Very simple forms, very easy to complete. When they're done, you're going to have a design meeting with me. And that means you're going to come back either in person. Most people like to just have a virtual meeting at that point. We have our meeting and we talk about the design of that plan. Who's going to be your agent? Who's going to be your trustee, your executor? What are your wishes for burial or cremation? That meeting is usually about 15 to 30 minutes. It's as long as you need it. We do have a lot of conversations surrounding a lot of things that may be important specifically to you. Again, I like to let you know for scheduling purposes, if your life is crazy, hectic, and busy, like everybody else's. And then at that point, you either have things that you need to still think about, or I start drafting. But my point is, this is not an overnight process. This is not something that will be one and done. The goal is that we're creating this plan for you, and that as your life changes, we're revisiting with each other and changing that plan according to what's changed in your life. I want to thank everybody again for joining us today, for wanting to hear what I had to say, and for really taking the most important step in educating yourself on why it's so important to think about this right now and what the dangers are in waiting to get that done. Thank you so much. And I'm really looking forward to the opportunity to meet you in person and be able to help you with all of this. Thank you so much.